Welcome to Immigration and AI, how companies and foreign nationals can take advantage of new and improving immigration opportunities webinar put on by WR Immigration. I'm Anna Bealey. I'm the Director of Marketing and Business Development at WR Immigration. I'll be running the webinar today. I will hand it over to our speakers, who include Cliff Rosenthal, who is a partner at WR Immigration, and Nathan Grove is a senior associate also with WR Immigration.
Thank you very much, Anna, and I'm sure I'm speaking for Nate as well when we say we're very happy to present to all of you on this very topical issue. Just as we are lawyers, we do want to start with a disclaimer. And that disclaimer is really that everything here today is not meant to be legal advice for your specific situation. Just like you wouldn't do self-surgery, you shouldn't do legal self-surgery either. It's really just to give you enough information to ask the right questions, to reach out to a competent immigration lawyer. It could be us, it could be one of your choice. But the real purpose is really to get the information. This is informational purposes. Really to give you the information to ask the right questions and to develop a strategy with a competent professional in order to achieve your immigration needs. A little bit about WR just to start off with. We're an immigration law firm. We have some awards. You can look at the slide yourself. Bottom, some of our awards that we're particularly proud of, our values. We try to bring together technology as well as high-touch, competent counsel, creative counsel, and that's what we're trying to do for you. So let's move on to the next slide. So the main purpose of this webinar is really to look into the October 30th, a few weeks ago, about a month ago, executive order that came out from the Biden administration on the safe, secure, and trustworthy artificial intelligence. Essentially what this is, it is an executive order that deals with AI and how AI is going to be dealt with in the future. So, well, which is really almost the present. It is the present. I think anybody who's been paying attention can really understand and appreciate that that AI is really, what's considered to be the dominant technology that's going to drive, the economies, into the 21st century. I think just like the internet revolutionized every single industry, I think that's exactly what's going to happen, and is already happening in terms of AI at this point. So the Biden administration, took the lead in the executive order. That's kind of the map, the plan that how they want to see immigration. Well, not immigration, but just it's a general order. It's really how they want to tackle AI. And they want how they want to make sure that it's safe for everybody. They want to make sure that America's at the top of the AI arms race, so to speak. How it's going to be safe for everybody, and how it's not, going to result in any type of inequity or discrimination. So if you look at the slide, you can kind of see what they're looking at. And interestingly enough, the question comes up is, what is an immigration details doing in an executive order on AI? In fact, there are quite a lot of immigration provisions on AI in this executive order, and the real answer is that immigration, getting talent in AI are synonymous with each other. Really, it's the move, to get ahead in this arms race, so to speak. That is based on getting the best talent possible, the most advanced talent possible, and getting that from wherever it comes. So that's kind of the context. If you look, they say most of the top AI companies in the United States are either started by immigrants or the children of immigrants, or it's very much an immigrant based field where everybody's coming from all over the world. The top people are coming from all over the world. They're coming here to the United States, both to start companies, to learn, to study in the top universities in the United States. And America has this very, very critical. It's considered part of the national interest, part of national security, that we can retain this talent, number one, and attract this talent, number two. So that's really what we're trying to do. So the executive order does go into different types of really just different type of bullets that deal with with how they can advance immigration. So just a couple of them. I'm not going to go through all of them just because they're kind of technical, and a lot of them are subjective and vague at this point, just because they're the plan that is intended to go in the future. So,
but if I could jump in and just ask you a question, by the way, about this executive order. Why do we need this for immigration law? How come we don't already have laws on the books? Why is it such a challenge? Is it such a challenge to get AI professionals here?
So that's an excellent question. And the truth of the matter is we do have the laws on the books. We have lots of laws on the books and lots of immigration laws on the books. But sometimes, as you'll see as we go through this presentation, we'll see that's almost like putting in a square peg into a round hole. That we have the laws, but they're not really, they detailed, and they were created for immigration, for professionals, accountants, lawyers, not necessarily for AI. And the move is really to move from the old antiquated system to a system that really deals with AI and its specific idiosyncrasies, as we're going to see throughout this program. And one of the major parts of AI is that you have whiz kids and people that are especially as a new technology, you have people that are whiz kids that don't have degrees in this, or that they're not that many PhDs in AI itself, or you have a lot of people working in different parts of AI that that don't have a degree, and trying to get the system to really to match what the laws are at the moment is really the challenge. And that's what the executive order tends to do. So the question is, how is this going to work in practice? Because we've got different laws that certain things that are already laws that have been in regulations we can tweak. Things that need regulatory new regulations are obviously going to take much longer, and they're harder to do. So what this executive order kind of addresses all of that. On the one hand, there are the executive order dictates a thorough review of all the visa categories, and to see how everything can really fit together with AI. So we're going to see a lot of changes in the way they look at it. There's even something in a general order in the executive order that says that DOS, the Department of State, and the Department of Homeland Security actually have to look at whatever discretionary authority have and use that to support those that are experts in AI. So that's kind of on the very subjective side. And then they're going to look at all the rules. So if you see on the slide, there's the O1 visa, alien of extraordinary ability, the EB1, which is the green card version of that. You've got EB2, which have different versions, perm versions, national interest waiver versions, as we're going to see before. So how can those be changed? How can those be changed to facilitate what's going to what's happening in AI, and it can really put forward the immigration needs of the United States in order that they can stay ahead of this race. They can attract talent and retain talent.
So Cliff, just to clarify here, so the executive order does not actually change anything. There's no specific regulation that's outlined here. There's no legislation outlined here. It's just a direction to DHS to look into this. So they're going to look into it. And then what could DHS potentially change for these categories here?
So there are some very specific parts as well. So in other words, there's one of the main issues we're seeing, and this is all around the world with all type of visas, is appointments to get visa interviews. So there's a special directive in order to streamline that. I'm not sure exactly what streamline means. Streamline can mean a lot of things. It can mean, make it very, very quick. It can mean more efficient. I'm not sure. It's a very vague word. But the point is that, and this has actually been ready to be started. It was announced this week that for those getting visas renewals, they can do that in the United States for H-1Bs. So it's also one of the directives that they'll have this program as well for those in AI, just as they do for H-1Bs. So that's something that's very specific that they're supposed to consider. Lots of information, a lot of information that that the government has to provide to those in AI, so that they know what their what they're doing. They're knowing what what they need to what to do in order to stay in the United States. They're looking at the Schedule A program. This is a program that looks at pre-certifying those positions or occupations that are in high demand in the United States. In other words, there's a well-known shortage in those occupations. Adding AI to the list. There's looking at changing the J program somewhat in order to add skills to the list, or maybe remove skills for the list, so people don't have to go back for 2 years. They can stay here. There's their directive to try to improve the adjustment of status process so that it can become easier. But as you mentioned, it just depends on what's going on. So as we said, this is a map. It's not a law that's been that's already been implemented. But certain things are can be done with discretion. They can be done under the current regulations with little tweaks. And some directives will need major regulatory law, and that will kind of go into the geopolitical sphere, where we're going to see we're going into election year, immigration, whatever it might be. Even things everyone can agree with is usually a hot topic, and difficult to get things passed very quickly. So as we said, that's the roadmap.
Can I ask, so talking about all these different kinds of changes that could be made that are, outlined without perhaps enough specificity in this executive order, if you could look into your crystal ball, what do you think actually what actually will happen, let's say, before the presidential election? What is there time for? Is there time for rulemaking process to make significant changes here, or is it going to be other kind of changes? And if so, what kind of changes?
I mean, there's definitely there's definitely time for new regulations, new rulemaking. The question is, is there the will to do that? And that's really a political question, and we'll see. My personal opinion is I don't think too much will change in terms of regulations, which kind of means I think we, looking at the traditional categories, looking at the traditional laws we have, the traditional policies, where the DHS, Department of Homeland Security, does have very wide discretion on interpreting its own laws, and I think that's where we're gonna see the major impact at this point. So a few years ago they did change a lot of their policies regarding to STEM fields, which is not quite AI, but is certainly a very close cousin. And we saw that they changed quite a lot. That quite a lot of their interpretations and policies that would help with AI as well. So I kind of see them using that as a platform, as a kind of example, as a template for what they plan to do in AI. As we mentioned before, it's not quite the same, because a lot of AI positions that are not STEM positions, and we're going to talk about that a little bit later. But essentially, I think that's really what's gonna happen. The real impact is going to be number one, on looking at the current policies and redirecting them so that they can support AI positions. and then a lot of information that I think is going to be out there to help those in these fields.
So Cliff, what about H-1B? I think among my clients who have AI specialist professionals, H-1B is still perhaps the most common non-immigrant visa category, but has its issues, doesn't work well, limited number of H-1Bs available every year. So is the executive order going to help at all? What does it talk about in regards to H-1B?
Right. So it doesn't say too much about H-1B other than there's a need to consider how they can improve the H-1B program. It comes from different parts. One part is actually using HI to make the system better, more secure, less subject to fraud. So there's that side, and then just looking at the looking at rulemaking, as they say, they're going to consider rulemaking, and how they can use it to help AI perhaps even get some sort of specific AI positions that could with STEM as well that they could that include. But again, these are going to need rulemaking, and that's more difficult and a longer process to do. So essentially, I think the H-1B program is not going to be changed too much by the executive order. There is a new rule for the H-1B independent of AI. It is possible that that rule's obviously very far along compared to certainly to the directives in this executive order. So we're going to see if part of the thinking and the ethos of the executive order can really be included in that. I mean, we had a point where the really public comments. So I don't think too much can be changed specifically, but we may be able to see some changes based on the comments. So
and the concern that folks are raising with that H-1B rulemaking and process is additional language that seems a little stricter perhaps in terms of tying H-1B positions to a related degree. So obviously that's the requirement of H-1B, a degree tied to the field. But the USCIS's scrutiny for how close that tie has to be has gone up and down, right? Under the Trump administration, many RFPs, and recently, not that strict on tying it closely. So how might H-1B rulemaking impact AI and other emerging technology professionals?
Right. So, I mean, your typical AI positions, your scientists, your software engineers, usually they are, taken care of by the current system. They usually have degrees that are somewhat matched. As Nate, you mentioned, it's kind of gone up and down how immigration has really reviewed the match between a degree and a particular position. So, for instance, do you have to have a software engineer degree if you're a software engineer, or can you have a different degree? And sometimes you get MBAs that are very tech or IT based, but MBAs nevertheless, or sometimes you have different types of position in AI, maybe an ethicist or something that is not, that the degree can be in a different field. And the question is how is the new rules going to look at it? It does seem, as you mentioned, that the new rule, kind of codifies that it has to be, there has to be a match, has to be a direct match, but I think there's still some leeway to look at different fields, and the new rule also makes clear that a range of fields can even be included. So I think really that the field, if the field is completely different, computer science position, the person has a degree in English, I think that's where we might get pushback. I think your degrees that make sense, a degree in statistics, or even if it's not exactly, but it's somewhat AI related, I think there is leeway. in the regulations, number one, and number two, within the the directives and the ethos of the executive order as well.
Yeah, and obviously, when we're talking about AI and other types of emerging technology, the industry leads the way. Schools and degree programs related to what the industry is doing may lag behind, and SOC codes that you need for H-1B lag perhaps even further behind. So it does create just a little bit of anxiety for me, at least. So when they're talking about H-1Bs need to have a close match. And, I have professionals that are in fields that they don't study to prepare for exactly what they do in school. And there's no job code that exactly matches perhaps what they do.
Yeah, and I think especially in the AI space, there's certain companies that I know that are looking for the whiz kid, the kids that don't have any degrees or self-taught. It's just such a prevalent type of candidate that AI really is looking for. That I think this is something that has to be dealt with at some point. I think there has to be some sort of visa based on the occupation, on the fact that this person is qualified in other means. Otherwise, it's gonna be hard to really put through the goal of attaining and retaining an AI talent, so that America can be the leader in this field.
Yeah, but when it comes to H-1B, we can complain about those types of things, getting people approved. But the number one complaint everybody has about H-1B is there's not enough of them, right? To get through the lottery is only getting harder and harder. And does the executive order have any indication of help coming in that area?
Nothing specific. As mentioned, they are, they have to consider, rulemaking related to the H-1B program. And as you mentioned, if you don't really deal with this issue, number one issue, your standard professional visa, the H-1B, is chronically oversubscribed. I mean, hundreds of thousands of applicants. Then I don't really see how this can the executive can really help. It's really so. If you want to keep people in the short term, the H-1B is the main visa at the moment, and this is oversubscribed, as you mentioned. They aren't enough. So this I assume will have to be dealt with eventually. But again, this is dealt with through the regulatory process and maybe even the statutory process. So it's not going to be a quick fix for that.
Yeah, and as well, there's no help for the other primary complaints and difficulties we see, right? The backlogs that are only getting longer for employment-based green cards and delays in adjudications. Well, you did mention they're pushing BOS to adjudicate faster or to hand out visas faster, but otherwise, this isn't offering a lot of help, right?
Yeah, especially on the green card. I mean, the point would be that if H-1Bs were oversubscribed, at least we would have the option of offering green cards to these people. But you have the same problem; they're also oversubscribed. Maybe maybe even worse than the H-1Bs. So you really kind of need a dual process to attack this. If you want to keep AI people in the United States, you're going to have to provide them with a path to visas and a path to green card. I think if the laws don't deal with that, then I think I think it's going to be very hard for America to compete in this arena. I think people are going to consider other countries as well. We saw this a lot with the medical funding, medical research funding in the 90s. When I started with immigration more than 20 years ago. All medical research funding was done in the United States, and slowly it kind of moved to different countries, South Korea, China. At one point they had very small programs, and today their programs are very big. And perhaps one of the contributing factors was that we couldn't keep people here, and they left. And hopefully we can address this in a different way when it comes to AI, that we can keep the people here. We can offer them, some sort of certainty or almost certainty in the way that, you know, the immigration strategies can be done. If we don't have options for them, it's going to be very difficult.
Yes, for sure. And there are other countries around the world who are bending over backwards to lower the hurdles for AI professionals to come and start companies, contribute their skills there. And so, yes, for sure, we need to do more because this is a race, and we don't win the race by keeping up the same old hurdles that have prevented people from getting here and staying here to contribite their skills here.
So, Nate, let me ask you a question based on one of the questions in the Q&A. It's one thing talking about AI, but what AI? What is AI? Does it only apply to software? Is it what is the scope of AI?
Right. Well, certainly we help people involved in all kinds of areas related to AI. We represent startups and more established companies that are working on various different kinds of AI products. And so that includes people working on the tech side in all areas: hardware development, machine learning, data processing, data science, generative AI. We help people with all of those. And so it's and then also, everybody else that a company might employ, accountants, HR, anybody else who's foreign national, we help get visas and green cards for them as well. And for each person, you have to kind of look at it on a one-by-one basis as to how are they going to fit for H-1B? How are they going to fit for any other non-immigrant category or green card category? And, we created this slide here to just kind of have a hypothetical thought experiment to show where the challenges are for AI professionals. So this is a hypothetical AI professional who we're saying has an MBA, so coursework focused on AI and human-computer interaction. We'll say this Asimov here is from India, bachelor's degree in commerce, so that does not scream technical background. And this person is currently an entrepreneur in residence for a VC fund in F1 OPT status and working on co-founding an AI startup. And so this is the type of person that we, of course, the country, it's in our interest to keep this person here, have this AI startup that they're working on here rather than somewhere else. But, looking at this sample background, you see some challenges, right? As we're talking about for H-1B, there's a little bit of a concern if you've got a bachelor's degree in commerce and an MBA, but you're going to work on the technical side of AI. Or if you're going to be a co-founder of a startup, there's an issue with H-1B with employment. You cannot be self-employed. You need an employer. If you're founder or co-founder of a startup, you have to think about that. So a lot of times for these folks, we will look at O1 instead. And, the USCIS is very open and accommodating right now for O1s for startups. We do a lot of them. A lot of them have been approved without much of an issue, but you do have to hit the O1 criteria. And this sample individual, you have to kind of fit some square pegs into round holes, right? There are criteria for O1. If somebody is in a leading and critical role, this person, I don't know, entrepreneur in residence and then a co-founder, is that going to be a leading or critical role? You have to make some arguments. There's a criteria for awards, named as a rising star in the AI conference. If that's it, you might be a little worried. You're going to have to make some arguments to hit that criteria. And then the O1 criteria do not specifically call out social media following, but you can perhaps fit that into one of the criteria as well. Cliff, I don't know, if this was a resume that came across your desk, somebody looking to found a startup and get sponsored, do you have any thoughts as to how to make it happen?
Yeah. Yes, I think I think you hit the nail on the head, so to speak. I kind of look into the O1, first really because of the question of self-employment. I think that could be problematic You have to show the employee-employee relationship for the H-1B. So there may be ways to do it if the person's a minority, a minority owner, if they're, there's an independent board. But I think there are some difficulties with self-employment, and that's kind of the major part, the major obstacle we see with co-founding. I think the policy manual on O1s, when it was adjusted for to promote STEM fields, I think is very helpful. And I think this is where most of the impact will be from the executive order. I think we're going to, for instance, when they talk about awards, does a monetary award count as an award, and just things like that, where there is some leeway, where perhaps in the past they've been kind of restricted interpretations. There are, there will be less restrictive interpretations going forward. I think when we're dealing with press, non-traditional press and social media and blogs, if you can show that they are somewhat distinguished, I think that is going to be your key. It's really kind of geared for the O1. There's comparable evidence for the O1. If something doesn't fit exactly, I think they're going to be the immigration is going to be very tuned to that and working in with the ethos of the executive order in pushing this through. So that's kind of what I would look for in this kind of application. But you need to have somewhat of a startup. You would have to have some funding. You'd have to show some legs to the to the company before applying for that.
Yeah, and we've already seen USCIS update their policy manual, especially with respect to tech and to entrepreneurs, to guide USCIS toward making the criteria more flexible and accepting of that entrepreneurs, that co-founders can hit these criteria. So if out of this executive order there's some additional policy manual updates that make it even clearer that somebody like Asimov here should fit the O1 criteria, that would be great. So the other hypothetical to talk through how this comes across our desks often is our AI clients say we've got a candidate for this kind of role, and sometimes we look at the job descriptions and say, this isn't quite a good traditional fit, right? Say you're hiring an AI ethics specialist. And we all have an interest as a country in admitting the best and brightest AI ethics specialists. I think 10 or 20 years ago, these jobs didn't exist. But now we're all interested in ensuring that AI is fair, non-prejudiced, not racist, and does not steal, does not violate data security concerns. The executive order talks about this. But yeah, if I have a client now that's looking to hire based on this job description and I see there's no specific degree requirement, then I'm a little concerned. I would love to see something come out of this executive order that would help to make it clear that this is a role that can get H-1B. If somebody's got a degree that reasonably fits with what they're going to do, and would love to see that this is the type of position that, like somebody like Asimov, this hypothetical person could get an O1 to fill this kind of role for a company. That would be great. It seems like it would likely be doable, but it's not easy enough. If we're trying to be the leaders in AI and get the best and the brightest, what we have is not sufficient, right, Cliff, to make it clear that this is an easy sponsorship role.
Right. I mean, we have very specific rules and regulations, very specific categories, and they kind of relate to the person's qualifications rather to the requirements of the position or requirements of the national interests of the United States. So, if you're dealing with this situation where you have a position that's clearly in their national interest, but the person's qualifications, at least university qualifications, don't meet the requirements. So you almost you have to discard the H-1B, which is really your traditional, your most common standard professional visa, and you kind of have to look at the O1. And as Nate said, depend on the situation. If the person's strong or not, that will depend on, what about the person, who's going to, who has kind of experience in this position, but maybe no publications or extraordinary ability that's in the regulations. And, they definitely qualified, they're self-taught, they've learned online, or they've, done it, they're just very technically very good. I think that's clearly lacking in the immigration system, and it's something that needs to be addressed for sure.
Yeah, and Cliff, you mentioned that companies in AI and emerging technology are looking for the whiz kids, right? And more and more often, we're seeing no degree requirement like this, right? Because they want to be open and get the self-taught, get the innovator who the non-traditional background, didn't go to school necessarily. And so their job offers are written open like this. When you see this, are you throwing up in your hands and saying, well, you just can't do H-1B. You said no degrees required. You just say you're out of luck.
And I see this very often. I see it almost every day. There's there are different things we can look at, and one being one of them, and there are some other creative options that we can look at. But essentially, with a job description, a job requirement like this, you kind of excluding the H-1B. I mean, there are some ways to frame the job requirements. As the new rule shows, it can be a range of closely related job and fields. So if it's not a specific degree, then that might fit into that, just depending on the wording. It might not, but there's certainly as you mentioned, there's just not enough talent. Everybody's going over after a limited amount of talent, and it's a new field, it's cutting edge, and the degree system probably hasn't kept up with it either, so that there are lots of self-taught people that are doing this, and it's we need to find a way to capture that. I mean, a lot of the leaders are these whiz kids, that's for sure.
That's right. Yeah. Well, absent help from DHS, from additional regulations or legislation's not going to happen, but absent any help, what this takes is creative thinking, I think, right? Thinking outside the box and coming up with a creative solution to make something work. Well, to transition here, speaking of creative thinking, what has become very open and flexible now for AI and for other areas as well on the green card side of things is this national interest waiver category. We have seen in recent years the walls and restrictions and unreasonable RFBs and pushback from USCIS come down for this category, which is really great to see. So quickly, for those who are not familiar with the national interest waiver, it is a EB2 green card category where the individual needs to have an advanced degree, meaning at least a master's or a bachelor's plus 5 years of experience. Alternatively, if you don't have a degree, you can show exceptional ability by meeting some outlined criteria. You have to be working in an area that has substantial merit and national importance. And you do not have to actually have a job offer. It does not have to be sponsored by that employer. It can be self-sponsored, and it can be looking down the road. It does not have to be for the work you're doing right now. You have to show that you're going to be well-positioned to advance the national interest. And then you have to show, on balance, it would be beneficial to the U.S. to waive the requirements of a job offer and a labor certification. In other words, that's the waiver, right? A waiver of the perm process. You don't have to go through and recruit for a hypothetical position. You're working in a area of national interest. This is the category that gets you a waiver around that process. So talking about national interest, what is an area of national interest? Well, in the past, I think this has been a bit more restrictive, and this is where now I think the doors are wide open. If you're working in any area that benefits the country on a national scope, it can work. And a lot of times the way we approach this is Is there a law about what you do? Is there an agency overseeing what you do? Is there a White House policy or executive order about what you do? Then that likely is going to work for NIW. AI certainly does, and we file a lot of NIWs for AI, a lot of NIWs for various different fields of emerging technology, which includes machine learning, robotics, quantum computing, medical research, all kinds of pharmaceuticals, health, scientific research. It's a very broad category that we've only seen getting broader in recent times. So let's say you are an employer looking at green card processes for your employees. Traditionally, a lot of employers have gone straight to perm as the default option if you're going to sponsor an employee for a green card. And more we're seeing our clients ask, well, what about national interest waiver? Do we have to do perm? Companies have difficulties and issues with perm, especially lately. You know, there was a large Apple settlement recently announced, previously a large Meta settlement about perm practices that make a lot of people concerned, even more concerned than normal about doing perm. Also, perm seems to be slower than ever right now. The Department of Labor, very, very slow. You're talking about often 2 or 3 years to get through that whole perm process and an I-140 approval. Too slow. And when you're looking at the green card backlogs, also too slow. You're starting the process, you're not going to get a priority date until you file the perm application, which is way down the road. So more and more people are seeing the benefits of NIW from an employer's perspective, right? With an NIW, you're going to get an I-140 approval much faster. You're going to get a place in line in the green card backlog much faster. In the past, people were concerned about the risk. Well, the risks are very low now for NIWs. All kinds of NIWs are getting approved without much pushback. And then, the question I've always gotten from clients about perm is, if I pay for this whole process for the employee and then they leave, I can get my money back. I'll just ask them to pay for that perm process that I did. No, you can't do that with perm. Regulations say employers must pay basically all the costs of the perm process. On the other hand, if an employee says, give me a national interest waiver instead, not only are you going to save money overall, because it's usually cheaper than perm, but you can also recoup that if the employee leaves. But if you sponsor an employee for perm or for an NIW, and you say, if you leave within so many months or a year or whatever afterwards, then you need to repay all or part of it. That's allowed, whereas that is not allowed for the perm process. So let's flip this around and look a little bit from the employee's perspective. If you are a foreign national, what is the benefit of a national interest waiver for you versus perm or another green card pathway? So number one, you can sponsor yourself. You don't have to wait around for an employer to sponsor you. You don't have to wait around to get just the right job. If you are working in the national interest, you're going to continue working in the national interest. Sponsor yourself. Take control of your own green card pathway. It also then helps it when you're looking for future jobs down the road. With the perm process, you're looking at restarting the process every time you change positions. With a national interest waiver approval, you can have one approval and be done. That not only takes the burden off of the employee, but it makes you more attractive to a future employer, right? If I'm an employer hiring somebody in H-1B status, I'm already calculating and adding the cost of a perm. If I hire that employee, big expensive perm. If I am hiring an employee and they say, I've got an NIW green card, you just got a lot cheaper to that employer, which gives you a competitive edge over other candidates for the job who need a perm sponsorship.
Yeah, I just wanted to add maybe that that the national interest waiver was really made for these AI, for the AI executive order. The statute is very broad. It just means it's a green card category just to serve in the national interest. It's that broad, and it gives immigration certainly a lot of leeway in ways to fit in AI and to really be supportive of this category. And they really want you to do it as well, because if you look at the policy manual, all the updates when it came to STEM, which, as we said, is the template for AI, is really in the national interest waiver policy manual. Everything that's what they want you to do. And in a sense, perhaps perm is more difficult in that regard, as Nate was mentioning. So this is kind of what the government want you to do, and that makes it a great option.
That's right. And so when you talk about that executive order, you don't really have any notes for national interest waiver to make it any easier for AI professionals. It's already easy. It's already a very flexible category. Made even more flexible when they added premium processing for NIWs. You can get premium processing and adjudication within 45 days for national interest waivers. We do have a couple of questions. The Q&A is open. Please add in any other questions you have. Cliff, one here. Could TN be an option for an AI position that does not require a degree under the computer systems analyst profession?
I mean, it definitely can. So the TN works a little bit differently to the H-1B. The H-1B, you're working with different, with general principles. Any position that requires what they call a specialty bachelor's and a bachelor's specific field will qualify. With TN, there's a list of occupations, and you either have to be in that occupation or not. And as the question alludes to, the occupation is computer systems analyst, which is one of the occupations. So it definitely can be. With the TN occupation, each occupation has its own requirements for qualifications by the foreign national. So the qualifications, the qualifications for computer systems analyst, there's a bachelor's degree or a post-secondary certificate plus 3 years of experience. So you'd have to, if you don't have the bachelor's degree, you need the post-secondary certificate, which, there's certain requirements. There's a number of years depending where you go to school, Canada or Mexico, but you would have to show 3 years of experience, and you can substitute that for a bachelor's degree.
And we have not talked about TN so far, right? Because it's not addressed by the executive order, and it's not necessarily the category of a lot of ways to immediately add some flexibility, right? And it is a little stringent on fitting in those categories, which are even more limited than the H-1B SOC categories.
Yeah, essentially, it was negotiated by NAFTA, or the predecessor to the current agreement. So, when something's negotiated, it's more difficult to change. But
would have been nice to add in when they renegotiated NCA, but it didn't happen. Immigration was...
Well, I didn't change anything. They just grandfathered everything else, yeah.
Okay, how about for NIW, do you recommend to prepare the file with professionals, attorneys, or is it a process that can be achieved by anyone as well?
I'll take that. You can also pipe in, but I think I know it's almost self-serving. It is self-serving, but I think whenever you can get legal representation, I think that's you should go with that. If you don't and you want to take your chances, some people can do it, and they can do the research and they can put it together. Just that we wouldn't recommend surgery, self-surgery. You wouldn't ask a doctor to do that. What you would ask a doctor. These are the kind of things that generally immigration attorneys do handle, and it's definitely recommended.
Yeah, and I mentioned that it is very easy. So I don't know. Who knows? If you feel up to it, maybe you submit it, maybe it does get approved. But I would just note, NIW petitions are still complex, even though they're getting approved. You're usually talking about hundreds of pages of the forms, support letters, reference letters, supporting materials. So we do think that our services are worthwhile when it comes to helping people prepare NIWs. are the criteria that define an AI professional, e.g. the Asimov case. Does somebody working in strategy, finance, fundraising at a startup using AI, but with no technical AI background qualify? Yeah, so with each individual, you're going to look on a person by person basis as to what are you going to do? What is your educational and experience background? And you have to strategize for each person. What category is going to work for a non-immigrant visa or for a green card? Typically with our AI clients, we don't usually find individuals where they want to hire somebody and we say, there's just no way, right? I mean, there's always something you can come up with, regardless of what you're going to be doing for an AI company. We're hopeful that the EO is going to add even more flexibilities, but if you are anybody that it needs to visa, non-immigrant, or green card sponsorship to work for an AI company, there's likely going to be a way. It's just a question of how risky and how are you going to do that?
I think it's a very good question, because I think certainly going forward, I think everyone's position is going to have some aspect of AI as part of the integral job duties. So, what actually, what actually qualifies as an AI professional, I think will have to be fleshed out, and it will be.
The question is, I think now, Cliff, are you an AI professional? I think maybe we are.
Somewhat. I'm improving.
We use AI every day through our tool Rapid.
Actually, Nate, I didn't tell you I'm actually a robot. No, jokes aside, I think I don't think it's going to be limited only to what you would call typical AI professionals in the sense that software engineers or the people actually coding or whatever. I think it's really going to finance people definitely will be included, but you're going to have to make that extra link. You're going to have show that nexus. Why is this an AI position? What are you doing? What are you doing how are you using AI to reach the company's goals? And I think it might be more difficult in more of the standard AI positions, but it's definitely not excluded. And I think in many cases we can make good arguments.
Here's a good and important question. If someone already has PERM and I-140 approved and is waiting for a green card under the EB2 category, what are the steps for applying for a national interest waiver? Does the PERM become invalid if the national interest waiver is rejected? No. I think if you're talking about multiple green card paths, one typically does not affect any other. If you have a PERM-based I-140 approved, that means you've got your place in line in the green card backlog. You can apply for a different kind of green card, and for an NIW, you still get the benefit of your priority date. An NIW approval is only going to help you because it'll allow you the flexibility to move around to a different employer and still get a green card without a new PERM.
Yeah, I think we've seen that.
PERM.
Yeah, I think we've seen this strategy quite a lot, where people file more than one, and just in recent times with recent layoffs. You have your PERM, and then why not do a national interest waiver? If you're laid off, it might give you some basis to stay in the United States, or at least if you find another position, not to have to start another PERM again. And that goes back to what Nate was mentioning in the advantages of NIW over PERM. But a lot of people with PERMs file NIWs just for that reason, to even if they've got that PERM, even if they're not going anywhere, they don't think they're going to be laid off, but it's almost like a little bit of an insurance policy.
That's right. And more we're seeing people that want to jump on the NIW first. Get your place in line in the backlog. NIWs can be possible when you are about to graduate, recently out of school, before you're really settled into a job you're going to keep for a while. Just get your NIW approved. Down the road, you can worry about EB1, trying to get there faster, trying to get into the faster queue. Just get your NIW done first. Do biotech professionals enjoy a similar advantage when it comes to NIWs and this path?
I mean, definitely similar. I mean, I would think most biotech professionals, depending on the position, would fall under the STEM initiative, so the STEM policy. So it is very similar. That just as we mentioned many times, the the STEM is the template for the AI going forward. So depending on the position, but certainly those that are research scientists and have STEM degrees would be in a similar position. Yes, that's for sure.
Agreed. Yeah, lots of NIWs for biotech right now, for sure. Does NIW allow you to start an AI company in a business executive position? Very clear.
Yeah, I mean, yeah. So I mean, when we talk about NIW, is it's a green card category. So that, we know there are two stages of the green card. We call it your basis for immigration, why America wants you, and then your actual immigration, which we call your adjustment of status. So that an NIW is really a basis for immigrating to the United States. And what typically happens is that, and it's not always the case, but in most cases, it's more of a long-term strategy. And because it's a long-term strategy, it's not very practical for those wanting to start a company. If I say you do an NIW and then you can start the company in 2 years, it's not really practical. And if you're from India, born in India or China, then it's there have been more backlogs. So it's really not really a practical solution to start a company. You really look at one of the temporary visas to start the company. The O1, the H1B if possible. We've spoken about the limitations already, and maybe some of the other options. But this would be more your long-term strategy in order to remain in the United States permanently and run that company and develop that company.
Yes, that's true. NIW is going to be something that's going to work. Yeah, if you are looking to start an AI company, but you do have a little bit of a chicken and egg problem, right? You need the company to get down the road to an NIW or perhaps to an O1. You need the O1 or the NIW to start the company. So that's something to talk through with an immigration attorney to strategize how to make it happen. How about could using AI for fraud detection, machine learning models to prevent identity theft be a good area to apply for an NIW? Yes. Yes, no, that would be. That's not all there is to it, right? There's more standard to it, but yes, I would just expect that somebody working on fraud detection using AI is going to sooner or later be a good NIW candidate. How long does it take for an NIW application getting approved?
I mean, right now, they're pretty quick. There are two processes. There's premium processing and regular processing. Premium processing is a maximum of 45 days. We see cases getting approved in a week, adjudicated in a week. So about a maximum of 45 days, but then you've got the extra expense of premium processing. With regular processing, it's very quick at the moment. I'm seeing cases being approved within 3 to 6 months. So those are.
Yeah, I haven't seen any premium processing NIW take the full 45 days or really even close. They are going fast on that. Now, yeah, save yourself the $2,500 if you're not in a big rush to get it approved. And yeah, it takes a bit longer, but also not that long. What pathways should a person with a bachelor's degree in computer science who co-founded an AI startup pursue? Bachelor's degree in computer science, co-founded an AI startup. Right. So if you're recently removed from that computer science degree, perhaps you're in STEM OPT, OPT status, that can be tricky with co-founding a company, being your own boss. We already talked before that can present challenges for H1B and for O1 as well. Not insurmountable challenges. You can structure a way to still make it work. So H1B and O1, national interest waiver as well, with a bachelor's degree plus 5 years of experience, or an NIW with extraordinary ability. Anything else, Cliff?
It's really kind of the Asimov example. So, just refer to what we spoke about that. There are definitely ways to make it work. But, there are challenges and there are limitations, and each case you can have to look at and determine, the best strategy.
Is it recommended to file an ED2 NIW while pursuing a PhD or after completion? It depends a little bit. Lawyer answer. Sorry.
Yeah, I mean, I think this is a great question, actually. I think you have to look. You definitely have to look at the particular situation. You have to look at the particular PhD, the person, the particular field, and the particular qualifications of the person. Some people in a PhD program, they publish a lot and a lot of citations. There's really no reason to wait. And we do a lot of cases with those in PhD programs. In other cases, when they're in the PhD, they're not, the case is not quite developed yet. Sometimes there are not as many publications or those citations, or, depending what there is. So when you're looking at an NIW, especially for those in research, that's kind of what we're looking at. But, it really depends on the situation. And there's certainly other factors. I mean, throughout this webinar, where we've focused quite a lot on the national interest waiver, we haven't spoken too much about publications and citations. So, if you can show for, what the national interest is, I think, there's no need to wait. So without publications and citations, maybe, you're working on some grant, or you're, something that's going to continue into a postdoc, or something that's very groundbreaking. There are other ways to prove it. So you kind of just have to, kind of look at someone in a PhD program, the students. You have to kind of look and just see, is the case developed enough to file an NIW? In many cases, there are. In many cases, and in fact, we do a lot of those.
But what about the well-positioned prong, right? You need to be well-positioned to advance it. So if you're in a PhD program, how much do you need to say about what comes after your PhD program?
Well, that's a good question. I mean, it goes really to the first point as well. The first prong of the national interest waiver, if you remember, is that you have to show that, national importance. So what you're going to do when you get your green card is in the national interest. If you're a student, then you're going to graduate in a month and then go on to a postdoc in a different state, different program altogether. That becomes relevant what you're going to do. If you have a postdoc, where you're going to carry on your research, even if it's in a different institution and the research is slightly different, I think that national interest would continue. So,
or a job offer, perhaps. What about PhD with a job offer?
Yeah, I mean, you have, at some point you have to show what you're going to be doing in the field. So a job offer is very good proof. As you mentioned before, job offer is not a requirement for a national interest waiver, but it's definitely good proof of what you're going to do ahead. There are other ways to show that. There could be letters of intent. There could be different, if you're going, if you're going to do your own project, even you could show how far, the organization is set up, that it's funding. It doesn't have to be exactly the same, but it's just really a question of how developed the PhD is, it's the person who's doing the PhD is, do they have enough stuff at that point, to meet the national interest waiver requirements, or, is it a little bit undeveloped and they have to wait until they get the PhD, or they have a postdoc, or etc. So that just depends. It depends on the case. And, as I said, many cases we do, during PhD, we've had no problems. Certainly not a ban on filing cases that before the PhD has been granted. That's for sure.
Thank you to everybody who came today and participated and gave us so many good questions. I want to direct your attention to the contact information for Nate and Cliff, which is on this slide. Also, we'll be sending out a link to the slides and a recording within a few days. So if you have any questions that you didn't get answered, please feel free to follow up with us. And thank you for joining us today.
Thank you, everybody.